Okay, so we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you, and good morning, everybody. I'm going to call the case first, 2019-P-1154, Robert Clifford versus Ruth Kelly. Before we begin argument, I want to thank all the parties for participating today in this remote platform. We promise to be patient with you if you have any technical difficulties, and we hope that you can be patient with us as well. I want to remind you that the same rules in terms of oral argument apply here as they do as if we were in the courtroom. Each side has 15 minutes. Now, with respect to the two attorneys appearing for the Clifford, is that correct, Mr. Keneally and Mr. Dunlap?
Yes, Your Honor.
Okay, Attorney Keneally, are you the only one who's going to be arguing this morning?
Yes, that's correct.
Okay, great. So the panel today is Justice William Meade, Justice Gabrielle Wolohojian, and my name is Ariane Vuono. With all that said, let's go ahead and begin. The clock will start in a moment, and Attorney Duclos, you can begin your argument.
Thank you. Justin Duclos, on behalf of appellants, defendants, Ruth Kelly, Jeff Cashman, and Elizabeth Cashman. May it please the court. This case was tortuous, not tortious. That is really the theme that I intend to impress. It was a convoluted set of facts involving three cases, and in the end, one case really prosecuted aggressively after the conclusion of the first two cases was done so to convert a tortuous fact pattern into a tortious claim, four tortious claims: invasion of privacy, trespass, assault, and abuse of process. Now, the first case, the adverse possession case, was filed in 2014. My client, Ruth Kelly, owns a home in Hingham. And there's
that case was resolved, correct?
Correct. That case was resolved, and it was not appealed. The result was accepted, and the parties were content to move on. But there was this outstanding case, which had been filed for alleged tortious activity while the adverse possession case was pending. The claims were all based on basically a 5-minute argument in the street between these two neighbors, between their houses, and through the process of what was a 7-day trial and repeated argument as opposed to testimony, repeated argument, it came down with at this point, a $400,000 judgment after there was only evidence of $2,000 in attorney's fees expended on the 258E case and $5,000 in alleged damages for planting shrubs between the properties, which evidence showed were already planned to be planted prior to the installation of the cameras that the plaintiffs allege invasion of privacy for. So you've got constant argument as to the intent of the appellants, the defendants, that they intended all along a master plan to win this adverse possession case in 2014 by setting up the plaintiffs, scratching their own car, and then telling the plaintiffs that he was responsible. One of the plaintiffs, Robert Clifford, was responsible for scratching the car, and that there was an attempt to have him arrested, and that this would then later be used against him in the adverse possession case or leveraged for settlement purposes. All of these allegations were premised on one key fact in the adverse possession case, which was an amendment to the adverse possession complaint in 2014.
Can I ask you a question, Attorney
Sure.
Duclos? I understand your interpretation or how you state the theory of the plaintiff's case, but isn't the biggest problem you have here is that the jury decided, as a matter of fact, that that theory was correct, that those things did happen?
If there were no errors of law, if there were no errors in the jury instructions, if there was no error in the admission of evidence, and there were so many, there were just so many. The introduction of an email that was sent during the course of the adverse possession case after Ruth's, my client's property had been damaged, she filed a 258E case to try to get to the bottom of it. There had been repeated damage to her property, and she took the recourse that the law provides. And though unsuccessful with that, she did not appeal that either, and was content to go about her life as she had before then, except the installation of security cameras to be sure that she could keep an eye on an unrented property. So this email was introduced as the sole piece of evidence to support an abuse of process claim. An email from an attorney to another attorney about a different case was introduced as a sole piece of evidence for an abuse of process claim. It was inadmissible on several grounds. It was never authenticated. It was hearsay. I mean, the brief, the defendant's brief goes into detail about the error of law that admission of that email presented.
Attorney Duclos, I have a question about this email. It looked to me from the record that there were two versions of the email that were admitted. One of those versions, your clients actually offered into evidence. The contents of that version were identical to the version that the plaintiffs introduced.
That's an astute note. It is. Our introduction came subsequent to the plaintiff's introduction.
Sure, but when you do that, don't you waive objection
I don't believe so.
to the introduction of the email to begin with? I mean, once you decide not just to, it's not just a situation where a document gets admitted over your objection and then you do the best you can to try to, you use it and try to diffuse its impact the best you can. Here, you actually then introduce it yourself in a second document. That seems to me different, because even if we were to agree with your premise that the email should not have been admitted when introduced by the plaintiffs, the evidence in the case would remain with that document in it because it was introduced by you. And so even if it doesn't constitute waiver, where would the resulting prejudice be?
I would categorize it as you did initially, that it was an attempt to mitigate the damage that introduction of that email, the initial introduction of that email created. And it was the best possible effort that the trial counsel could make to work through the issue. I mean, we had that issue on a motion in limine. There was supposed to be an instruction. I mean, that email was supposed to be introduced solely for the purpose of informing the jury of the date that the plaintiffs received notice of the 258E case. It was thrown around the entire case as evidence of a master plan to bring the plaintiffs to their knees in the adverse possession case. It just does not.
All right, I understand your argument. I'm struggling though with the fact that you did introduce it yourself. Your side did introduce it yourself. I take it you weren't trial counsel.
I was not trial counsel.
Right.
This is my understanding of the approach.
So,
was that
right? But so let's say that we were to go through the exercise of it. Let's say we were to conclude that the document, when introduced by the plaintiffs at trial, should not have been admitted for all purposes. And therefore, we were going to try to assess on appellate review what the prejudicial impact of that was. Don't we have to then consider the fact that the defendants themselves introduced the same document? That would still be in evidence. And where can we find prejudice when, even if we were to say that the first time the document was introduced, it was introduced erroneously, but there it is again in the evidence of the case, admitted for all purposes at that point?
I don't think it was. That's what I think is the difference. I believe trial counsel introduced it for the purposes of informing the jury about the date.
It's not indicated in the record that it's admitted for a limited purpose.
Well, I believe the judge made that ruling at the outset, at the liminal stages. I believe that the judge ruled that it was in the colloquy, in the transcripts, that email was supposed to be introduced solely for that purpose, and that trial counsel, defense counsel, when there was a second introduction, was trying to bring that email back into its proper box, which was for notice of the date of the 258E case. Basically, in effect, to try to limit the amount of prejudice that there was, to contain the damage. Now, the introduction of that email was a major error. But with 5 minutes remaining, I'd like to move on, if that's okay, if you have any other further questions.
Sure.
The email was also incomplete. It didn't attach the police report. That was the sole subject of the email, was to share the police report with the adverse possession counsel. Just courtesy, standard practice, to let people know what's happening in the case, people who will have a bearing on the case. So that's its own problem. And trial counsel, defense counsel was unable to introduce the complete email, even with the introduction that was made. Nobody was able to introduce the complete email.
Now, the judge allowed, at the time the judge denied the introduction of the police report, the judge also allowed the plaintiffs to testify to what the officers, Mrs. Kelly, I think it was, to testify as to what the officers told her. So in other words, what it was that you wanted from the police report, the judge ruled she could testify to that. Even though the police report itself couldn't come in, she could testify to what the information in there that she wanted. And then that testimony was never elicited. So why isn't that a problem?
Well, I believe that there was every effort to prevent discussion of conversation, communication, bilateral between the police officer who generated that report and Mrs. Kelly.
But I didn't see any question by counsel to Mrs. Kelly saying on direct or redirect saying, now what did the officer tell you?
Trial counsel was instructed to go nowhere near these subjects, and that police report was admitted for purposes of malicious prosecution, but not for any other claim. Plaintiff's counsel summarily dismissed their malicious prosecution claim for that sole purpose, to avoid introduction of the police report. And thereafter, that was unsafe territory. And trial judge made that very clear. And defense counsel was not about to introduce his own prejudice in the case by raising the subjects.
For me, your time is limited. For me, it would be helpful if you could turn to the question of damages.
Sure. The principal problem with damage is the lack of proof. There are nominal damages for trespass. That's how, that's just the law. Technical trespass is nominal damages. It's well established. There was no instruction to that regard, even though it was requested. However, there was an instruction for nominal damages as to assault. And then the jury, interestingly, came back and asked for clarification on the assault charge, and the judge refused to provide any on damages for assault, on how to assess damages for assault, where there was a nominal damages instruction. Now, we'll never know precisely, what what issue the jury took with the charge on damages for assault. But the fact that the word nominal appeared there, that's not colloquial language. Nominal damages it's a term of art that needs to be defined, and the jury needs to be charged with that. And they sought clarification, which was not given. And then there was no charge given for nominal damages on trespass, no nominal damage charge given for invasion of privacy. In fact, the whole jury instruction for invasion of privacy was wrong. It was only half given. Right out of the middle of a sentence from the Polay case, they took the first half and not the second half. And there was strenuous objection made to that as well. So you got evidence of $2,000 in damages for attorney's fees in the 250-AD case, and $5,000 in plantings, which were already supposed to be a part of their plaintiff's landscaping plan, and then very thin testimony as to reputational harm and emotional distress type damages. There simply wasn't sufficient evidence, and in all events, if there was going to be any award, it would be nominal, and the instructions on these subjects were wrong. Could I answer any further questions? Otherwise, I'm content to rest on the brief.
I see no questions from the virtual bench here. Thank you very much for your argument. Appreciate it. Okay. Attorney Keneally.
Thank you, Judge Vuono. May it please the court, I'm Kevin Keneally, and with my colleague Ben Dunlap, my partner, we represent Donna Clifford and Robert Clifford, the plaintiffs' appellees. The trial evidence established that the defendants engaged in physical intrusion, physical intimidation, physical force, all to coerce the Cliffords to give up their land. The case was proved primarily through defendants' own witnesses and their own words. We proved through their witnesses that Ruth Kelly damaged her own car. She scratched her vehicle. And then Mrs. Kelly and Mrs. Cashman used the scratch on the car as a pretext to attack and invade the Cliffords' home, their land, their persons. All of this was animated by an adverse possession case that had gone bad for them. Their weapon on the street in the yard on July 5th, 2015, was an enraged Mr. Cashman. They attempted to use also the Hingham Police and then the Hingham District Court as additional weapons. And then when that failed, they surveilled the Clifford children and the Clifford's backyard and private areas of their property where they shower and lie on a hammock, for instance. And their private lives were intruded upon in a very ugly way. And that was as retaliation, but also to coerce the Cliffords because the adverse possession case was still going. They were trying to force them to give up their land, to put the driveway of Mrs. Kelly and the Cashmans back on the defendant's land. We heard this morning, it's in the brief as well, that it's reversible error because some email was the sole piece of evidence. That's simply not true. Exhibit 23 was a foundational document. It might have been one of the first documents of liability that went into evidence through one of their witnesses. Exhibit 26 is the interesting document, which was put in by the defendants themselves without any objection, with no limiting instructions. That told us and told the jury that there would be no peace, there would be no settlement, there would be no return to neighborliness until the driveway was placed back onto the Clifford property. Any compromise necessarily in the document involved disturbance of the Clifford lot. There was overwhelming admissible proof that all of these torts against the Cliffords impacted their lives, not just in the street on July 5th, not just in the humiliation on July 15th when Robert had to go to court, not just when it was in the newspaper in town, not when the detective went from house to house to house to house on Oregon court, but it continued for years, most tangibly with the surveillance camera that was trained on their backyard. So they were reminded daily of their vulnerability, that they were at risk, that they had enraged, entitled neighbors, connected neighbors in the town. They had a neighbor who was watching loops of their children playing in the yard. There was much testimony about the capabilities or lack of capabilities to extract evidence from the surveillance camera, but there was trial testimony about Mr. Cashman sitting in the basement watching the family.
Did counsel make a suggestion as to the measure of damages during closing argument, like the amount of damages?
No, we did not.
Nobody suggested any numbers to the jury?
The plaintiffs did not, except for, I believe, the $2,000 that the criminal lawyer was paid, perhaps the $5,000 that the extra shrubs that were put in the arborvitae to block the cameras.
And what
The motive, however, I didn't mean to interrupt, but there was a number put into evidence by the defendants. They elicited from Mr. Clifford that he paid some ungodly amount of money to protect his rights in the adverse possession case, and that became their motive. If you read the closing arguments, they hammer him that maybe it was because he has a person of means and they were trying to infect the jury, but they hammered him about damages, about this amount of money that he had been forced to pay. But that was defense's trial strategy, and that was their number.
So in your view, the jury's award was to compensate the plaintiffs for what types of harm?
The jury's award was to compensate for the results of 4 separate torts, the abusive process, which the damages for abusive process are attorney's fees, emotional harm, injury to peace of mind, injury to feelings, and injury to reputation. And there was tangible evidence, supporting evidence on all counts that Mr. Clifford underwent that. He had to withdraw from civic activity. In the street, the neighbor told him Jeffrey, don't get involved with Mr. Clifford. Your reputation is better than his. He was falsely accused to the police and to his neighbors and his community. He was in the community courthouse, recognized people in the courthouse. It was reported in the town news, as I said. So there were tangible evidence of abusive process. The surveillance went on and on and on. The evidence was that Donna Clifford wouldn't tend to her garden in the backyard, that she was fearful. At some point, she had a no trespass order on her. So if she went too close to the hedges, she might have the police down there and arrest her without warrant. And the damages recoverable include the impact on the peace of mind, the inability to use your property, sense of security, embarrassment, plus special damages. So those damages were amply supported, we submit, Your Honor.
What are the special damages here?
The special damages would be putting in the arborvitae, the expense of that, and
that's the $5,000?
Yes, Your Honor. The trespass damages, there was tangible evidence, admissible evidence, compelling evidence about how it impacted both Cliffords. Mrs. Clifford wouldn't go into the barn. The barn was the problem between the neighbors, I guess. They had a beautiful family room placed in there because the historic home did not have large rooms. That was their living area after the project. And that was where Mr. Cashman confronted, went right up, trespassed up to the door, ordered Bob out to answer the false charges about scratching mother-in-law's car. Donna Clifford would not be able to use that. She was shocked when it occurred. Stunned, I think was the word. And that carried on for quite a while. And fear of being attacked, an invasion of property, that's a separate property right, is different from assault damages, which are humiliation, indignity, loss of peace of mind and security, being humiliated before your spouse, and injury of feelings, and as the cases say, any distress that lingered in the mind. And there was testimony about how they reacted. and how it impacted the family to their personal safety. Donna would not go out without a cell phone because she was fearful for her personal safety. And all of these were argued to the trial judge in post-trial motions, Your Honor. And I'm sure I don't need to point out the appellate standard of Smith versus Bell Atlantic on a motion for remittitor is that the defendants need to prove that the size of the verdicts so shocked the sense of justice as to compel the conclusion that the jury was influenced by partiality, prejudice, or corruption. The defendants must separately satisfy this court that the judge's failure to remit the awards below was an abuse of discretion amounting to error of law. They do not even remotely come close to the standard for remittitor or for overturning a judge who carefully weighed the evidence. She saw the witnesses. She saw the ordeal that went up during trial, Judge Wolohojian. During trial, there were 2 new false allegations against Mr. Clifford and Mrs. Clifford. On the last day of testimony, the Cliffords were accused of stalking Mrs. Kelly at her new home in Rockland because they saw a silver car. This is before the jury. And that Robert was stalking her in the courthouse without any complaint to her honors, Judge Sullivan, to the clerk, to the 2 court officers, extraordinarily professional court officers in the courtroom, and amazing court security at the front gate. Nobody heard this, and they blurted it out at trial. And I believe that the jury was actually restrained in damages by seeing the ordeal they were put through and the unrelenting nature. That's 2 strikes for Bob.
Can we turn to something else?
Certainly.
I'm the anti-SLAPP motion, special motion to dismiss. That was decided, I think, before the decision in Blanchard, was it not?
It was decided before Blanchard.
But
Yes.
Blanchard nonetheless applies. We have a case that says that Blanchard applies because it's just the interpretation of an existing statute, and therefore it would apply. So we would apply that now in reviewing the anti-SLAPP motion.
Well, they had an immediate right of appeal, of course.
But they're not obligated to take it. It can be decided now.
Metzler versus Lanou suggests that it's mooted. That's a 2004 case from this court. When a special motion to dismiss is denied, the moving party presently loses that protection because she will then have to defend against the harassing litigation, go through discovery, pay a lawyer, go through trial. And that is why they're allowed to appeal immediately. Otherwise, the appeal will therefore be futile.
Well, that's different from moot.
I'm sorry?
That's different from mootness. They may not get the practical benefit of it, but it doesn't mean that it's legally moot.
Fair enough.
I had a case a couple of years ago that involved a similar situation. I think it was Reichenbach.
I have it here.
In the Reichenbach case, the anti-SLAPP special motion to dismiss was initially decided before the Blanchard decision. Then Blanchard came down, and yet we held that the Blanchard framework needed to be applied. So, we would need to do that here. And it looks to me, well, why don't you tell me what this looks like if we were to do that?
Well, I think if you look at the stage 1 factors, none of the torts here, none of the invasion of privacy, statutory right, involve petitioning activity. Having someone trespassing your property and beckon you out into the street, that is not court-based activity.
Right, but the abuse of process claim,
Yeah,
almost by definition,
well,
involves petitioning activity.
the courts say that there would be constitutional issues about that, but if I can find my paperwork on that. The Gillette versus Provost case says that Indeed, it is hard to see how any claim for abuse of process or malicious prosecution would survive without the use of these letters, the attorney's communication. So we submit that the letters were actually out of court conduct, out of court misconduct. It was, we filed the harassment litigation, and now we're using it to influence a different case. So that is not petitioning-based activity. That is
No, but their use of the 258E process was petitioning activity.
yes, and
So if their use of that is petitioning activity, then you get into prong 2, stage 2,
well, I
as modified by Blanchard, no?
okay, but the use of the case to leverage an outcome of a different case, I submit, is not petitioning. But for purpose of your question, if you go into the merits of the case, we proved that it was devoid of any factual basis, any proper basis. The lawyer, the dear friend who prosecuted Mr. Clifford, admitted herself that the case was very, very, very tenuous. The judge found that there was no basis for that case. You didn't prove 3 malicious acts. You didn't even prove 1, he found on the record. During the case, they hoped, and this is testimony, she hoped that the district court judge would call them in and try to influence another case. That is ulterior purpose. They proved it themselves during the petitioning, during that case. The case was proven to be without merit. So, and devoid of fact is one of the issues. I see my time is up, but I'm happy to answer any other questions.
You're muted.
If I may
I
conclude.
appreciate that. I see no, excuse me for having been on mute there. Seeing no further questions from the panel, we'll take the case under advisement. On behalf of the panel, we wish all of you and your families we wish you that you remain safe and healthy during this.
Okay, we are live.
Okay, thank you very much. Good morning. I'm going to start by calling the case officially 2019-0995, Phyllis Gold versus Thomas Gold. I want to thank both of you on behalf of the panel for participating in this remote format. I'll tell you initially that we will be patient with you if you have any technological difficulties, and we hope that you will also be patient with us if we experience any. So far, we haven't had any, so let's keep our fingers crossed. The same rules apply with respect to oral argument on this format as they do as if we were in the courtroom. So you each have 15 minutes to argue, and there is no rebuttal. The panel today is Justice William Meade. We're also joined by Justice Gabrielle Wolohojian, and my name is Ariane Vuono. With that said, we'll begin our arguments. Attorney Heinley, correct? Did I say it correctly?
That is correct. Thank you.
Yes. The floor is yours.
Good morning, Your Honors, and Kelvin Heinley for the appellant, and may it please the court. What we have in this case, I believe, where you have a marriage of 46 years and parties of 91 and 84 years old, respectively, at the time of trial, is a remedy in search of a problem. And what I mean by that is, we know on page 66 of my brief, which represents page 36 of 37 of Her Honor's findings, that she explicitly based the 60-40 asset division of this marital estate on only 2 factors. And those factors are disparity in the parties' earning capacities and the fact that, quote, it is inappropriate to award alimony given the parties' advanced ages, unquote. We know from the Hines court that substituting assets for an alimony award is an inappropriate thing to do, and that's a long-standing principle of over 25 years going back to Hines.
But it's not an improper principle to take into account a disparity in the party's earnings capacity, correct?
That is an appropriate factor under Section 34. But what you can't do, and I believe happened here, is if you look at the prior page of her findings, she heard a lot of testimony and heard a lot of evidence about the wife's gifts to her son, Philip, from her prior marriage, and Mr. Gold's transfers of his business interests and gifting out to his son, Thomas, from a prior marriage. She decides that those are all comparable and all reasonable under the circumstances, given the ages of the parties and their desire to estate plan. And she sets both of those two piles of gifts and business interests outside of the marital estate. She then immediately turns back to those very business interests she just excluded from the marital estate, and is the only factor that we have left under Section 34, which you just pointed out, is the parties' disparity in income and earning capacities. She then turns back to those business interests that she just excluded as the sole grounds for justifying an award of 20% of a marital estate to one party over the other, which has a value of over $800,000 in a marriage of nearly 50 years. When she
20%, I don't understand that. Your position is that it should have been 50-50.
When I say 20%, I mean 60 to 40. So if you,
Right, but Justice Wolohojian is correct, right? What you're talking about really is a 10% difference.
I understood. I was describing the delta.
All right,
but
just so we understand.
Yeah, certainly that's what I mean, is that 60-40 range. But yes, it would be 10% up, 10% down. No argument there. I think numerically,
is your point with so your point is, if I may continue this, if the marital estate was $8.3 million, 60% of that was close to 5 million, 4.98 or so. 40% was 3.3. If you added the value of the businesses, if you accept what the judge had to say and add the value, the 100% value of the businesses award to the husband, it would be even. But your point is that those businesses were not part of the marital estate, and so then it doesn't make it 50-50%. Do I have that right?
Correct, because she set aside the business interests not in a vacuum.
Okay.
Her Honor set aside those business interests at the exact same time and for the exact same reason that she set aside the wife's gifts to her son, Philip. They were comparable in value, they were comparable in timing, and they were comparable in intent. The parties were appropriately estate planning, and what you can't do is set aside those business interests and the wife's gifts to her son, and then pull back only the husband's business interests to justify a 50-50 when that's not what occurred. She clearly set those outside the marital estate, both piles.
But when you say that they were comparable, just so that we're clear, the judge valued the businesses at about 1.6 million, and the gifts to from Phyllis Gold to her son was less than that, about $1 million or so, right?
Correct. I think that you had, it was a little about $1 million, but then you also had what the judge found to be voluntary spending and different lifestyle issues, where she said that she would adjust what the wife had been doing in terms of paying for $40,000 vacations, which she didn't add up and tally onto the $1 million gifts to Philip. So it's somewhere between maybe $1 million plus excessive voluntary spending to $1.6 million. And even if we take that argument in a vacuum alone, then what the problem she was trying to remedy was not $800,000 or more, which would suggest a delta between the offsets of $1.6 million, because an $800,000 shift would make up for half of that. It's an inappropriate remedy because there was nothing to remedy. But even if there was, the value of what she did so far outpaces whatever concerns she might have had that it can't. Yes, Justice.
We don't normally focus, or we don't necessarily focus on the dollar consequences of these allocations that are usually made in terms of percentages. 55, 45, 42, 58, whatever they are. We normally look at the percentage without worrying too much about, did that result in a $250 difference or a $250,000 difference? So I have to admit that throughout your brief, I struggled with the fact that you kept focusing on what that allocation represented in terms of dollars. But if I look at it simply as a 60-40 split, without thinking about what the consequence of that was, the $800,000, I don't really see in your brief why that's outside the bounds of the judge's discretion.
I'll tell you why I think the numbers actually matter here as opposed to just the percentages, is because the only hook Judge Monks lists in her findings as the grounds for her having done this, whether it be 60-40, 58-42, whatever she chose to do, was a purported unmet need on Mrs. Gold's behalf. And if you're going to tie something to need, there needs to be specific findings as to what those unmet needs are.
Did she say need, or did she say disparity in parties' earning capacity?
Disparity in parties' earnings capacity is the element upon which she bases the decision, but the reason for the decision is the wife's unmet need. She says that multiple places in the findings that the wife can meet her reasonable needs because of this disparity in the party's earnings capacity, which she seeks to remedy through the 60-40 division. If you're going to tie anything to need, there has to be findings as to how the remedy, the award that's being given to her, ties to those needs. And before you do that, you have to establish what those needs are. And I would respectfully suggest that despite 37 pages of findings, there's no paragraph, there's no calculation, there's no section in these findings that shows why the number is $840,000 of need as opposed to, say, $720,000 or $26,000 or $100,000. It is as if she picked the percentage without examining the actual impact of that decision. And then in order to justify roughly $840,000 of need being made up through the sole element of disparity in earning capacity, what she's effectively said to Mr. Gold is you continue to work and earn through that earning capacity until you earn your way back to a 50-50. And as I pointed out in my brief, that would have taken him decades to do. If need, we know from the Balistreri court that the passage of the act did not change the fundamental underpinnings of need and ability to pay in an alimony case. And if that's the case, we know here that her maximum alimony exposure was a few $100s a week, roughly $500 a week. It would have taken him decades to earn and pay that back. If we consider need through the alimony, or not the alimony lens, but through the asset division lens, through a higher or future earning capacity, then we are telling a 91-year-old who was 92 by the time the findings were issued that he has to continue to work because that element is his way of getting to 50-50 in a 46-year marriage.
But isn't that maybe why she says that alimony is inappropriate here?
If she says that alimony is inappropriate, then the only place that she can be looking to use the word need, because need is usually a function of the alimony statute. The only other place in our law that we see the word need is section 34.
Can you point me, because I didn't really see the need as what she did was turned on need.
Sure, one moment I can.
She looked at the equal contributions of the parties to the marriage, the length of the marriage. She looked to all the normal section 34 factors. She
did. She talks about, the court talks about this on page, in her, unfortunately, it's in the section that relates to, it's sort of her summary, so they're not numbered paragraphs, but it's at the end of her findings, so I can't point you to a specific paragraph, where she discusses that the court does not find that the wife has a need for alimony and declines to deviate from the statute, but she goes on to talk about how the wife can meet her marital standard of living. It says, pursuant to the court's property division, she will receive assets totaling over $5 million. This, coupled with her own Social Security, retirement, and unearned income, is sufficient to meet her reasonable needs. That's the last paragraph of her finding. I see that. And so the only—
But that seems to me like a conclusion. I didn't see that anywhere in her analysis saying I'm coming up with this division because of a precise need calculation, like how much she's going to need every week to meet her expenses.
But I actually think that's precisely the point, is that if it's not tethered to some need, and the only element upon which— that's actually the point I'm trying to make, which is there is nowhere I can point to in this 37 pages of findings where she says this party, this wife, needs over $800,000 more than this husband, this other party. The only element to which she cites to justify doing so, because we know she says alimony is not appropriate, is his heightened earning capacity. Because as you point out, Justice, Everywhere else in the findings, she says the parties contributed equally to the marriage. There was no conduct that would justify anything else. So if the sole element upon which this decision is based, whether we look at it as percentages or numbers, as I tended to do, whatever lens we view it through, if the sole element is his heightened future earning capacity, then she's got to tie that on a 46-year marriage to something that the wife needs more than the husband.
Why? Why isn't it enough that he just earns more than she does?
Because what she's telling him then on that length of a marriage, despite their equal contributions and their equal conduct and all of the other factors, their ages, length of the marriage, if the sole factor is his ability to earn more than she does, that then what we're saying when he earns so little more compared to his earnings above hers is only a delta of about $1,400 a week. That's his earned income.
Yeah, well, she had some skepticism about some of the figures on his business side of things.
So even taking that into account, if we look at his total income, and even if you ignore all of the wife's income, he's earning just a few $1,000s a week. To get to the point where $840,000 of a swing is justified on the sole basis of his ability to earn more than her, it's almost incalculable how long that would have taken him at the age of 92 to earn back his way to a 50-50, because the way I read her decision on every other front and on every other element, and I think it's common sense in a marriage of this length, is that the presumption would be a 50-50, and that a 50-50 division was otherwise warranted but for his ability to earn more than her. And if we say to him on this length of a marriage and under these facts, the fact that you're earning you have a little over $3,000 a week in income, and she has closer to $1,400 a week in income, on that small of a delta, that a 10% or $840,000 swing, whichever way you want to look at it, is warranted on that small of a delta of income to somebody who's earning that income at the age of 92, I don't think is justifiable under the law, and certainly not with the lack of any specific findings or any specific rationale that lay out why that's the appropriate number. I don't think any remedy was warranted here given her findings, but even if there was a problem to be fixed here, why is the number $840,000 of non-taxable assets as opposed to anything else? I don't see any specific finding I can point you to where we say she had this amount of unmet medical bills that he had, or things like that. They're on equal footing throughout the rationale and throughout the findings on every other front. And if she was attempting to close that income gap, she did so to the tune of $840,000 when the income gap was far much less great than that. I see that my time's about up, so if there's any other questions, I'd be happy to field them. Otherwise, I thank you all very much for your time.
Thank you. I see no further questions. Thank you very much. Attorney Nardone.
Good morning. May it please the court, Robin Lynch Nardone on behalf of Phyllis Gold, wife in the underlying divorce action. I want to start with the issue of whether a 60-40 division of assets was within the court's discretion after weighing the factors under Chapter 208, Section 34. Case after case, they're cited in my brief, tells us that no mathematical precision is required in dividing marital property, that a trial judge has broad discretion in division of marital property, that the trial judge is not required to follow any formula in dividing the marital property, and that the weight to be accorded to each of the Chapter 208, Section 34 factors rests within the sound discretion of the trial judge. Yet here, Mr. Gold, in his brief, argues that given that the trial judge found that the parties relatively equally contributed to the acquisition, appreciation, and preservation of the marital estate, that a 50-50 division is required. That logic ignores the 14 other factors found in Chapter 208, Section 34, each of which this trial judge clearly and well-reasoned, considered, and weighed. Ross versus Ross and the other cases cited in my brief instructs that contribution is but one of the factors, and it does not outweigh the other factors. In fact, contribution is one of the discretionary factors that the court not need even consider when weighing the factors in how to divide the marital estate. The court here did consider contribution and then also weighed it against the wife's lack of earned income, which is represented in the factors amount and sources of income, as well as it can be part of the factor of need. And she also considered the husband's retention outside of the marital estate of those business interests valued at $1.6 million. My brother argues essentially that in light of the court's determination that the wife did not show good cause for deviation from the retirement provisions, the court could not consider her lack of earned income when dividing the marital estate. This is without merit. When the Alimony Reform Act was codified at Chapter 208, Sections 48 to 55, there were also amendments made to Chapter 208, Section 34. That became effective on March 1st of 2012. The legislature expressly included in 2012 that when in fixing the nature and the value of property, if any, to be assigned, the court shall consider, and went through the factors, those 14 factors that we are aware of in the statute. I won't repeat them here. I'm sure your honor is aware of those, but that includes amount and sources of income. Chapter 208, Section 34 still provides, as it did prior to the alimony legislation, that in determining the property division, amount and sources of income shall be considered. Those factors do not drop out of consideration when alimony is not awarded, and those factors do not drop out of consideration when alimony is awarded. The same is true with the factor of estate. Again, with the enactment of the alimony reform legislation, Chapter 208, Section 34 kept in that estate is one of the factors that must be considered by the court. Here, the judge expressly found that the husband's retention of his business interests will provide additional financial security to him, and that his ownership of these interests has been factored into an unequal division in the wife's favor. I will note here that Mr. Gold has not challenged any of the findings in this case. The findings expressly took his expert's value as to the two business interests in determining that his 100% ownership interest, and I'll note, it's not the value of the businesses, but it is the value of Mr. Gold's 100% ownership interest is $1,621,400. This, of course, begs the question, does his retention of these business interests outside of the marital estate mean that those assets cannot be considered when fashioning a division of the marital assets? And the answer to that is no. Estate still needs to be considered. We can see that in the case of Nicholas versus Nicholas, which I've cited in my brief. The judge there did not abuse his discretion in considering inheritance that was retained by the husband when determining the share of the marital estate to be awarded to the wife. What we have here is not an unequal division of assets in lieu of alimony, but rather an unequal division after weighing of the factors expressly called for by the statute. I would point out the same paragraph that my brother pointed out in his argument at the conclusion of the judge's rationale on page 37, where she says that this asset division coupled with her Social Security, retirement, and unearned income is sufficient to meet the wife's needs and maintain the standard of living enjoyed during the marriage. Accordingly, the court does not find the wife has a need and declines to deviate from the retirement age provisions of the Alimony Reform Act. It was because of the division of assets that she fashioned that the judge then found that the wife did not have a need for alimony and declined to deviate. It was not the other way around. Further, to suggest that the division of assets was in lieu of alimony completely ignores the $1.6 million of assets retained by the husband, which the court plainly and expressly took into consideration in coming up with the unequal division. In the end, including retention of his businesses, the husband received assets of $4,975,000 and the wife received assets of $5,030,000. This cannot be considered unfair or what is unreasonable given the court's discretion in dividing assets after weighing the factors. We know from Connor versus Benedict, which I've cited in my brief, that all of the factors under 20834 remain relevant to a determination of the division of assets even after enactment of the alimony legislation. The judge plainly and clearly has authority to weigh those factors without a mathematical formula, which we are told in Williams versus Massa. Judges have historically unequally divided assets, and those divisions have been upheld by this court, including Bacon versus Bacon, where the wife retained $3.6 million of assets and the husband retained $200,000 worth of assets. Does the court have any questions on that portion? Otherwise, I'm going to discuss the issue of the allocation of liabilities.
I was just going to ask you about that.
Okay. So the issue of the allocation of liabilities, there was $182,000 that the husband indicated was due to Tomac Packaging Inc. and $191,000 that the husband said was due to Lincoln Warehouse Inc. The court elected not to deduct those from the husband's assets in fashioning an equitable division because she found highly unusual business dealings and business transactions between the husband and his son, Thomas Gold. And the court had great difficulty crediting the reported business-related debts and receivables at their full face value. These debts were not evidenced by any promissory note that came into evidence. The $182,000 was salary that Tomac Packaging Inc. paid to Mr. Gold's personal legal secretary in his law office. She was not an employee of Tomac Packaging Inc., which is a highly unusual way to make payment for an employee who does not work for the company. This was not evidenced by any kind of paperwork and was just a running tally on the books relating to the payroll. The $191,000 was reported by the husband, but in his testimony, which is at page 864 of volume 10 of the transcripts, the husband was unable to recall the reason for this debt. And there's no promissory note. It's just a number that he put on his financial statement. The court's credibility determinations as to whether or not these debts were real and whether or not these debts would be repaid was entitled to deference. And so our position is that she made a credibility determination relative to these liabilities, determined that they were unlikely to be repaid, and therefore determined it was not equitable to deduct these from the balance of the assets in determining the division of the marital estate. Does the court have any questions on that area?
I have one question about the issue of alimony. When the judge says that an award of alimony would be inappropriate, is it your view that the judge reached that conclusion? I couldn't quite tell if it was because of the age of the parties, or if it was because there's a presumption that alimony won't continue past age 65 under the statute, and she couldn't see any reason to deviate from that presumption, or some combination of these. When she said that it was inappropriate, what in your view do you think was the reason for her conclusion on that?
My reading of her determination of it being inappropriate was that given the ages of the parties pursuant to the statute, the retirement age provision would kick in based on their ages. And therefore, it was necessary for the wife to prove that a deviation was necessary under the factors of the statute. Then in light of the fact that she made this division of property, it wouldn't be necessary to deviate given that the wife would have sufficient assets to meet her needs going forward. So when
I hear you say that, I'm wondering, why isn't that exactly what the husband is arguing, which is that division of the assets is in lieu of the unequal division of the assets is in some ways tied to or in lieu of an alimony payment?
It's not, because the judge made the determination that in looking at their unequal earned incomes, that this, and coupled with the husband's retention of $1.6 million, that this division was appropriate in weighing the factors. After having made that division, she looked at the alimony and said, given the division that I have made here, I don't see a basis to deviate from the retirement provisions of the statute, which indicate that it would be a burden on the wife to show that she would need the alimony beyond the durational limit set by the retirement age. And the court here said, I've made this division of assets. In light of that division, I don't believe the wife meets the factors for deviation. So I look at it as backwards from what Your Honor is saying.
Thank you.
Okay. So then the final issue that I would like to raise before your honors is legal fees. Phyllis Gold is 87 years old, and she has been involved in litigation relating to a divorce since 2015 when she first filed her complaint. She has been deprived of the use of $840,000 of marital assets, which the trial court properly awarded to her. Those $840,000 are being held in escrow and have earned approximately $2,300 in interest over the course of time that those funds have been held. She has been met with delay since very early on in this case, when she was forced to file motions to compel to even get the most basic discovery under Rule 410 at the start of the case. There were roadblocks put up by Thomas Gold to obtaining information about the businesses. He also filed a Superior Court lawsuit, which the trial court found to be unfortunate and to cause both parties to have incurred additional legal fees. The husband filed an appeal of the judgment terminating the marriage, which was ultimately dismissed by this court. Now here we are 5 years after this divorce was filed, and she is still responding to frivolous filings, causing her to incur substantial legal fees to defend an appeal from a very well-reasoned, very fair, and equitable division of the marital assets, well within this court's discretion, based upon 254 in-depth findings, not a single one of which has been challenged by Mr. Gold. So it is time for the frivolity to end, and Mrs. Gold is being asked for, is asking this court to award her legal fees in this case.
Okay. Thank you very much. Thank you both very much. We'll
Thank
take
you,
the case
Justices.
under advisement. I'd like to conclude by saying on behalf of the panel that we hope that you both stay safe and that you and your family stay healthy.
Same to you. Thank
Thank you
you.
all very much.
Okay, we are live streaming.
Thank you very much. Good morning. Good morning to you both. I will call the case first, 2019-1628, VV versus a minor. I want to remind you that the case, of course, you know the case is impounded, but I want to remind you of that before we start. I want to also thank you on behalf of the panel for participating in this remote format. We haven't had any technological difficulties so far this morning, but if we do, I hope you'll be patient with us, and we promise we will also be patient with you should that occur. I also want to remind you that the normal rules of appellate procedure for oral argument apply to oral argument here as well. Each of you have 15 minutes to argue, and there is no rebuttal. The panel here is Justice William Meade and Justice Gabrielle Wolohojian, and my name is Ariane Vuono. So with that said, we can begin, and I believe Attorney Sullivan Puccini, you're the appellant, correct?
Yes, thank you.
Thank you.
May it please the court, Sharon Sullivan Puccini on behalf of the minor, MI. I'm going to first start with the extension order hearing and what happened at the beginning of the hearing before doing the initial hearing. In this case, the judge's remarks show that he was predisposed to issue the order right from the start. You can see in the transcript that he is annoyed. He's interrupting the attorney when they're speaking at the beginning. What happens is the plaintiff's attorney calls her to the stand, and then she asks if they can sequester witnesses. And then the judge, asks, "Oh, well, how many witnesses are there?" And then they explain. Then he says, "I have young people here, and I don't want to make it too, And so
I read that as the judge being concerned about the fact that in fact the parties most involved were young teenagers.
Yes. Absolutely. Absolutely. I would note that harassment orders are sent to the juvenile court, but restraining orders are in the district court. And it is an intimidating situation to be a 15-year-old. They were both 15 at the time of their dating relationship. And at that time, they were both turning 16 in September. So yes, it is. But it's not just that he was concerned about the juveniles. It's almost like at the beginning, right from the start, he says to them, I've read the affidavit, and basically at certain times and places, he says they were basically either confronted or chased her, grabbed her. And then he says, "So why wouldn't I issue the order?" Well, the attorney then goes on and says, "Well, I have the police report. We have the school report. There's disputed evidence. We have video." The judge cuts her off.
Puccini, then then the judge actually hears all the evidence, though.
He does hear the evidence, but it has permeated the entire hearing.
But there was no allegation of bias, was there?
I'm calling it he's predisposed from the beginning that he wants to rubber stamp the affidavit.
Was that brought to his attention?
Was it brought to his attention? She continues to present her client's position, MI's attorney, that he needs to hear the evidence. She keeps saying, you need to hear the evidence. And he keeps saying over and over numerous times, but you're not saying that she wants to see him. Over and over. She's not saying, I don't want to have anything to do with him. Again, it's like 4 or 5 times he says it over and over. He does end up hearing, correct, he does hear the testimony. Just before the coach gets on to testify, she says, the attorney for LV says, I'm going to have the coach testify. Now, this coach hasn't told the police officer that she didn't even observe anything that day. She's the only one that testifies for LV, except for LV saying yes to the judge's question that she's afraid. But what happens, even at that point, the attorney for MI says, Your Honor, this witness doesn't, and he cuts her off and he says, I don't care. And I went back yesterday to listen to the recording. His tone, you can see, it goes up many times when every time she's explaining at the beginning, oh, there's inconsistency disputed. I don't care. He's arguing almost with her. And then he says, I don't care. He says, I don't care 2 other times during the proceedings. One is when the counsel for LV is saying, I have bruises, plural. I have bruises of incidents. Well, she didn't have pictures of bruises. She had one picture of one bruise dated June 28th. The affidavit says that when that incident happens, going to the bus, he grabs her, pushes her, and then there's a bruise. The bruise is dated June 28th. So she makes it, and she also makes an authentication, and he says, I don't care. He also says, I don't care another time when the SRO is on the stand providing testimony. And he says, LV's attorney is questioning him, and he says, Your Honor, there's an issue with Google Docs. And he's saying, well, I have the Google Docs, and I have, and the judge says, and I just want to know which account they're coming from. The judge says, I don't care. So that's another time. So it's permeated the whole time. It's that he almost wanted to.
When I read it, I got the feeling that the judge was trying to refocus the attorneys to the fact this was not a criminal trial. It proved beyond reasonable doubt did not apply. The ordinary rules of evidence do not apply as long as it's fundamentally fair, and that he wanted to focus the parties on those things. And for example, authentication was not required with the photograph.
Correct, Your Honor. That is the correct standard, but it also has.
And counsel, I think, as Judge Vuono pointed out, no one raised an objection along these lines to Judge Hourihan, right?
That he was not being fair? That
he was preempting the proper presentation of the case.
Well, I do believe at the beginning she keeps saying to him, he was not gonna present evidence, but he does. So he does let it happen. So I'll go on to specifically the argument of why it's not why the standard wasn't met. But I'd also just reiterate, Justice Meade, that the rules are flexible. It's supposed to be expeditious, but it also has to be fair. It has to be fair. Every time she would object, counsel for MI, it was, I don't care, and the other side.
But he did hear the evidence of the chasing on the field, of the bruises and the text where MI threatens to kill himself if he does not, if she breaks up with him.
So I'm going to go into the standard for what had to be proven and how our argument is that it wasn't met. So going through the affidavit, there's the incident in the hallway at school on Friday, September 20th. I think it's important that she tells them at first that he has grabbed her and pushed her into a wall. Then she says then she tells things to the friends. And the claim is that he waited for me outside the locker room, and then he chased me onto the field. But that is, it's not even just contrary evidence. It's proven not to be true. The SRO had been in the hallway just feet away. He even walked by them at one point and said, "Is everything okay?" They were not upset. No one's angry. The vice principals also talked to a student who had gone by it 2 times, that she didn't see anything physical happen. The school report says that they looked at the video. There's no indication of anything going on.
There were
The
problems
SRO
with the video though, right? The video didn't capture the whole scene, and its quality was low, and you couldn't make out who was who on the video. So
no, that's the video talking about going. No, the testimony, if you look at his testimony, is the video does not show the running to, you know, he just does say you can't say exactly who's who, but they can see the girls going. It's specifically disputed by Judge Gleason about waiting outside. And then the interesting thing is he goes out first.
Excuse me, that's the preliminary order, correct? The September 23rd one?
What do you mean that's the preliminary?
I'm sorry, which order are you talking about?
We're talking about the extension order.
All right.
So that's totally disputed. The coach says he leaves first, so he's not waiting for them and chasing them. And also, the retraction, she says grabbed and pushed, and you know, later she goes in and says, well, this is specifically what she says to them.
He clenched his fists at her and backed her into a wall.
She does not say that. Interesting enough, she does not say that to the police. She says shook hands. She says to the vice principals in their report, it shook hands and he was angry. And specifically, she says, I was not afraid. She tells the vice principal she's not afraid.
She tells the judge at the end of the hearing that he has read the affidavit, and are you afraid? And she says that she is.
She does, but I have it's our position that is not enough when there's so many inconsistencies, so many disputed facts, disputed by video.
The judge, those are credibility determinations though, and the judge gave MI's counsel the opportunity to cross-examine LV, and he decided to go to closing arguments instead.
What ends up happening is she's crying during the hearing, and I'll point out again that she was going to be on the stand, and then the judge started this whole discussion and she starts getting upset. So she's crying. What had gone on over and over at the hearing, MI's attorney does not cross-examine. He only asks one question. The father wrote the affidavit. He doesn't even take the stand. He says specifically in his affidavit, I would be happy to talk about this. He doesn't take the stand. We have one.
But could I always forget the initials, so I'm just going to call him the boyfriend.
Yes.
The boyfriend.
Okay.
Could the boyfriend have called the father? Father was present.
The boyfriend could have called the father,
And
but it's not his.
Boyfriend could have called the girlfriend, who was also present. So.
But it's the plaintiff's burden, even though it's a low burden. I understand that it's their burden.
So in those circumstances,
We're having a problem.
Little technical problem with Justice Wolohojian. Can you hear us?
I can hear you.
I wonder if Justice Wolohojian can hear us.
Yeah.
I don't think she can.
Oh,
There's
she's back.
back.
Respect.
And
Just we'll stop a minute and we'll make sure that you have your time gets restored.
Okay.
Do you want me to change the time to 5 minutes?
I think that's about the time when a problem first started, correct?
I think so too.
Okay, so we'll do that once we have Justice Wolohojian back on.
Okay.
I'm sorry about that.
That's okay.
I could hear and see everyone, so I don't know what was going on my end. Am I clear now?
You're clear now. You're back on. We're going to set the clock back to 5 minutes when we first had the glitch. So we're all set to go. Okay. You continue.
you need to re-ask your question.
Oh, so my question was, you know, where I'm not quite sure what inference you're asking us to draw from the fact that the girlfriend and her father did not take the stand when the defendant, who could have called them, also chose not to.
Okay, and what I was explaining was the reason the girlfriend's not called is because she's crying, basically, and the way that the hearing was going, she doesn't end up calling him. And I was pointing out, Your Honor, that it is the plaintiff's burden to prove that she's in, you know,
Right.
imminent fear. And I just want to
use, if the judge decides to credit the affidavit can be the evidence upon which the plaintiff meets her burden of proof.
Correct. But I want to point out a case that two points I want to make on that about credibility. I sent in a 16L letter, LO versus GO. And in that case, it's a 128 decision. I should have pointed out in my letter. And it says a statement that the plaintiff is scared is not sufficient. The fear must be objectively reasonable in light of the facts adduced. Not only that, I didn't point out, which I realized later, footnote 2 is there were no further evidence with respect to the affidavit's reference to the defendant blocking the plaintiff when leaving the bathroom. Absent explication, the allegation is insufficient. So she testified at the hearing, but there was nothing about that specific point. So there's numerous points from the affidavit that they're just in the affidavit. And my credibility argument, because I knew you would ask this, is how can he make a credibility determination based on specifically her just her demeanor? She didn't testify. All she said was yes.
No,
and there's so many disputed facts.
Sure, but there's also corroboration from the coach. Not necessarily on every point of the affidavit, but there are important points of the affidavit that are corroborated by the coach's testimony. There are, ancillary forms of corroboration in the other witnesses' testimony. There is, to me, it struck me as significant that school administrators were concerned about the nature of the relationship. I mean, I don't have a huge body of reference for these matters, but that doesn't pop up in every case.
I'd like to address that point specifically about any prior abuse. I addressed that in my reply brief. There is absolutely no records of any concern between these two of abuse, of anything of concern. That is coming from the teenagers who tell that to the assistant coach Moynihan. That's coming from them.
Excuse me, the two coaches, they staggered the practices so they would get out at different times to avoid these two coming into contact with each other. That seems significant to me.
That was after, Your Honor, that was after the first order was put in place on the Monday. This hearing's on the Friday. So the first one, that is only why they did that.
And the resource officer himself was so concerned that he sought the emergency order in the first instance.
It was not that, it was the parents wanting to. If you look at the police report, it's the father, and the father specifically says to the police officer that he wants to get a restraining order. He doesn't know what he's capable of because Li's parents abused him. And the SRO says, later in this investigation, that's not even true.
What inference could be drawn from the fact that when the girlfriend goes to talk to, and I forget who it was, about the fact that she wanted to break up, and this adult says, I recommend that you do it in a public place?
That is interesting, because throughout this case, I've said, why is an adjustment counselor saying that?
Maybe to protect.
Well, because if you're in a high school guidance department, these days, the emotions are so high, social, emotional, that I think that was uncalled for having them do that. She's basically doing it based on what the girl's saying. I'm nervous to do it. They go above and beyond on doing it. what they should be doing. And nothing happened. Absolutely nothing happened. He didn't get upset. No one was upset. And again, he didn't even think they had broken up.
So maybe the guidance counselor's advice was pertinent, was helpful. In other words, the whole point that she said to her is that this should be in a public place and that that'll keep things calmer. And that was the reason why she was advised to break up with him in a public place, when also she and the school resource officer could be present or watch them.
Yeah, but if you go back and then I didn't even get to talk about the text that they was texting that night. That they going back and forth. I'm sorry, what happened? And he's saying this whole subculture of teens where they didn't actually break up because they're only, I don't know if you have teenagers, but they're only talking, and they're not dating technically. So there really wasn't a breakup, and they make a big thing about that. And
all right, I see your time has expired.
I'll just rest on my brief on the other issues. Thank you.
Yeah, there's no further questions from the panel. So thank you very much.
Thank you.
Okay, Attorney Green.
Yes. Good morning. I guess I will just start with regards to the argument that Judge Horahan rubber stamped the affidavit, and I would argue that that is not true. That in fact, the standard is for Judge Horahan to conduct the restraining order with fundamental fairness, and to listen to both sides, and to with regards to the evidence that was admitted. And in this case, Judge Horahan conducted a 2-hour hearing. He allowed all four of MI's witnesses to testify. He reviewed all the exhibits. He even questioned witnesses directly. He questioned the defendant, MI. He questioned the soccer coach, and he questioned Officer Roberts. So he clearly was not just rubber stamping the affidavit. He was trying to determine the credibility of the witnesses for himself. And then after he questioned the witnesses, he allowed counsel to direct cross-examinations. There was even redirect and cross-examinations of the witnesses. So I would argue that MI was given a full opportunity to litigate the issues of credibility with regards to the affidavit. And essentially, I just want to provide some context with regards to the comments that MI is taking or is concerned about with regards to what the judge was saying. Essentially, what happened was the hearing started with the two attorneys going back and forth as to why the affidavit should issue, the order should issue or not. And so essentially what the judge was doing is he was just challenging the lawyers, saying, why should I issue it? Why should I not issue it? And it was based in that context that the judge was challenging the lawyers. And it wasn't that he was rubber stamping the affidavit. And specifically what MI argued was that you should be questioning the credibility of the affidavit. And the judge said, okay, fine, put on your witnesses. And at that point, that's when Ms. Moynihan, the soccer coach, testified, and he questioned the soccer coach at length. So, in terms of so first of all, I would argue that he did not rubber stamp the affidavit. Secondly, I would argue that the guidelines for the abuse prevention proceedings don't require the rules of evidence be strictly followed. And in this particular case, the issue is whether or not the judge had any bias towards either side. And I would argue that he did not display any bias, that he allowed all of the exhibits to come in without authentication, which included MI's witness evidence of there was text messages, there was a Google map, there was the letter that MI was referring to from the principal that had multi-level hearsay within this letter, and he allowed it all in. So I would argue that the judge was indeed fair with regards to how he conducted the hearing, and those concerns are not well founded. With regards to the photo of the bruise, I believe there was some concern about that coming into evidence. I would argue that the way that that particular photograph came into evidence, first, LV's attorney asked Officer Roberts about the bruise, and the Officer Roberts testified that it was MI's mother who admitted to the fact that MI told her that he did grab her arm. And that's the incident where LV said that she received the bruise. So I would argue that there was sufficient evidence for the bruise, the picture of the bruise, to be entered in at that point, based on the foundation that LV's lawyer provided, that there was in fact an incident, and according to LV, that incident resulted in the bruise. In terms of the, I guess, so I would just argue that Judge Wolohojian did conduct a fair hearing. If there's no questions with regards to that, I can move on to the extension order and the merits of the issuance of that. Okay. In regards to the extension order, I would argue that Judge Wolohojian did not abuse his discretion. He issued it based on the preponderance of the evidence that LV was in imminent fear of MI because she was physically abused and assaulted by MI. And MI refused to accept the fact that she was breaking up with him. And then he went so far as to threaten to kill himself if LV broke up with him. And finally, LV testified that she was in fear of him at the hearing. And as MI's lawyer did say, I mean, she was crying, she was upset. The judge had the opportunity to observe her demeanor throughout the hearing, and he made note of that on the record about her demeanor as well, and why that proved the fact that she was actually in fear of MI. So specifically, the evidence at the hearing proved abuse under 1A and 1B of the Chapter 298 restraining statute. And Judge Wolohojian's decision actually reflected that, because he specifically stated in his conclusion that his decision was based on the evidence he heard, the documents he received, the pictures he reviewed, the text messages that he went over, and that MI and LV had a relationship, and MI was in love with LV, and that LV may have feelings too, but he does believe that LV was in fear of MI, and so they should remain separate. So I'm arguing that Judge Wolohojian's findings that LV was in fear and they should remain separate met the criteria of both 1A and 1B. I believe that MI's counsel is arguing that the bruise occurred, basically it wasn't temporal to the request. I would argue that the bruise, according to LV, happened in the spring, that this particular hearing happened in September. And so I would argue that the bruise was in fact relevant and pertinent to Judge Wolohojian's decision. And the fact that it's an actual physical abuse puts that into a different category for the judge to consider. Specifically, in the Yana Y versus Sylvester H case, the court opined that, quote, when a plaintiff has suffered abuse, a judge may reasonably conclude that a 2098 order is necessary because the damage resulting from that physical harm affects the victim, even when further physical attack is not reasonably intimate. In Yana, the court found that the plaintiff was sexually abused when she was 8, and they still issued the restraining order when she was a freshman in college. So I would argue that the timing of the bruise, as in terms of the hearing, is not an issue in this case because it involved physical abuse. I guess lastly, I would just argue that it seems like the MI's counsel wants this court to substitute their desired credibility finding of fact, as well as second guessing Judge Wolohojian's evaluation of the facts. And that's not the standard. Where it is up to the court to determine and make the findings of fact and credibility assessments. And that's uniquely the province of the trial court. And the decisions are replete with the fact that they're not going to be disturbed on appeal. So I would argue that the law is clear that Judge Wolohojian is supposed to make credibility assessments based on the witnesses before him. He is supposed to look at the totality of the circumstances and determine whether or not LV's fear was reasonable, given the fact that she had been physically abused as well as assaulted in the past. So basically, I would just argue that Judge Horry had more than sufficient evidence in order to issue this restraining order, and it was done appropriately. Does the panel have any questions for me?
So extension order going to expire in September?
That's correct.
Any further questions from the panel?
No.
All right, I see none. I see none. So I want to thank you both very much for your
Thank
argument.
you.
We'll take the case under advisement. On behalf of the panel, we hope that you both stay safe and that you and your families stay healthy. All
Thank
right,
you
so
very
take
much.
care.
Thank
You're
you.
Bye-bye.
Bye-bye.
Bye now.
Right.
All right, Jean, we're just going to wait to say